For over 150 years, courts have been reading the wrong version of federal civil rights law. Not a typo, not an interpretation, an entire sentence deleted in 1874 that Congress wrote to protect your constitutional rights. Every qualified immunity case since then, every single one, built on a statute that's missing the text Congress actually passed. I'm Brandon Grable, civil rights attorney. I interviewed Professor Alex Reinert, the legal scholar who discovered this 150-year-old error. He explains what happened and why judges across the country are calling it game-changing. First, what even is qualified immunity? And why should you care?
So qualified immunity is a doctrine that kicks in when someone is trying to sue a federal or state or local official for violations of their rights, usually violations of their constitutional rights, although qualified immunity can apply in statutory cases. And what qualified immunity does is say, well, look, if you want to hold this person accountable in damages, you've got to show that they violated clearly established law that a reasonable officer, that every reasonable officer would have known. So it sets this threshold that basically, even if you can show that your rights were violated, if you can't show that the law was clearly enough established to the officer at the time that your rights were violated, you won't be able to obtain usually any remedy at all.
Clearly established, that's the key phrase, and it's become a trap. Courts don't just look for a prior case with similar facts. They look for nearly identical facts.
You see some cases where an officer pulls someone over and uses force, let's say, on the side of the road. And a court might say, well, yeah, we had a prior case a few years ago where we said using force against someone who wasn't resisting in this kind of context would be a violation of your Fourth Amendment right to be free of excessive force. But, in that case, it was dark at night, or it wasn't dark at night, or it was the middle of the day. And in this case, it's dark. Or in that case, it was in a residential neighborhood. And in this case, you're in a rural area. So little things like that distinguish a prior case from the facts in front of the court, sometimes courts will rely on to say, the law wasn't clearly enough established for the officer to know that in this context, they were violating someone's rights. And it can, to someone who's not a lawyer, or even to lawyers, it can seem awfully trivial, the distinctions that courts are making to say the law wasn't clearly established. But to some degree, the Supreme Court has encouraged that kind of analysis by lower courts.
So if a prior case involved a force at night, but yours happened during the day, it's different. If the prior case was in a residential area, but yours in a rural area, different. Different weapon, different location, different anything, the court could decide it's not clearly established. And here's the feedback loop.
I think it's important for your viewers to understand is when a court says the law wasn't clearly established, therefore qualified immunity, one important thing is not happening, which is the court isn't telling us whether or not there was actually a violation of rights in that particular instance. So every time a court says qualified immunity because the law wasn't clearly established, we don't learn in that case often whether or not there was a constitutional violation. And so it's just this feedback loop where the law never gets clearly established. It makes it very hard to establish new rights in new contexts.
Want proof? Ninth Circuit 2019. Officers executed a search warrant. During that search warrant, they stole $225,000 in cash, gold, Rolexes, and valuable comics. Stuff that had nothing to do with the search warrant or evidence. The homeowner sued. Guess what happened? The court said it's not clearly established that cops cannot steal your things while executing a search warrant. Qualified immunity granted. That's not legal doctrine. That's a system breaking down. So this doctrine blocks thousands of civil rights cases each year. Surely it's rooted in the Constitution, right? Or at least Congress passed it? Wrong.
So it comes from the Supreme Court's interpretation of a statute, Section 1983, which is the principal statute that is used to vindicate our federal rights against state and local officials. The statute was enacted as part of Reconstruction in 1871, but it wasn't really used in much force until the 1960s. And in a series of opinions, starting in the 50s and 60s and 70s, the Supreme Court said, well, we think there should be some immunity for officers who are sued under this statute, even though the statute on its face doesn't say anything about any kind of immunity, whether we would call it a good faith immunity or a qualified immunity.
In 1967, the Supreme Court just invented it. Judges made it up based on a legal rule called the derogation canon, and that's where the first error begins. The derogation canon sounds complicated, but it's actually quite simple. It's a 200-year-old rule that says don't assume Congress killed common law rights unless Congress explicitly says so. Think of it like software. The derogation canon says keep all your old settings unless the new program specifically tells you to change them. In 1967, the Supreme Court looked at Section 1983, or at least a corrupted version of it, and said, the statute doesn't mention defenses or immunities. It's silent. So using the derogation canon, we're going to assume that Congress wanted to keep the old common law immunity defenses. That is how qualified immunity was born. But Professor Reinert discovered a problem with this reasoning.
So in general, whenever you're interpreting a statute, there are these so-called canons of construction. They're basically shortcuts that we use for trying to figure out how to interpret a statute where the statute isn't obvious, where it's not obvious how to interpret it. One of those canons, one of those old canons, was called the canon that basically we should not infer a repeal of common law rights. That is, if there are common law rights, then the legislator will tell us they mean to do away with them.
Rights, not defenses. The derogation canon protects common law rights, like property rights, liberty interests. It was never about protecting common law defenses, never about immunities. And Professor Reinert didn't just theorize about this, he checked.
I went back and I read every Supreme Court decision from 1798 up until 1871 that applied the derogation canon, and I couldn't find a single one that applied it in the context of a defense. It always treated it as a canon that was about common law rights, common law rights that had existed for a long time, not some common law defense.
Error number 1. The Supreme Court used a 200-year-old rule completely backwards. They applied it to defenses when it was only ever used for rights. But that's not even the big one. Error number 2 is bigger. The statute the Supreme Court was reading, it was wrong. When Congress passed the Civil Rights Act in 1871, rights after the Civil War during Reconstruction, the law included something called a notwithstanding clause. Let me show you how it was discovered.
I was working on this article about qualified immunity, and I just came across the original language of the statute from 1871. And I've both been a scholar but also a litigator for a long time, and I continue to litigate civil rights cases. And so I was reading this version of Section 1983, and I said, I don't recognize, there's this language here that I've never seen before, and it was this notwithstanding language, right? What Section 1983 says is that people who act under color of law shall be liable for violations of the Constitution, and it says shall be liable in damages or in equity. And the original version from 1871 says shall, notwithstanding any such statute, law, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding, be liable. So there's this insertion of what I'm calling, and I've called the notwithstanding clause, right? That you shall be liable notwithstanding state law to the contrary. And given that the Supreme Court had originally located qualified immunity in state law doctrine, state common law doctrine regarding good faith, I thought, well, how has no one looked at this and thought it's significant here?
Notwithstanding any state law to the contrary. In legal language, notwithstanding is the strongest override you can use. It means, I don't care what else exists. This takes priority. Congress explicitly said state law defenses don't apply, including common law immunity defenses. So how did this sentence disappear?
After this 1871 Civil Rights Act was enacted, Congress decided for the first time it was going to put together all of the federal laws in one place. Like up until the 1870s, if you wanted to find a federal law, you had to go to the specific Congress, the specific records of the Congress that enacted it. Today, we just go to the code book, right? We go to 42 U.S.C. and we find the law. Well, that compilation of federal law didn't exist until the 1870s. So Congress, after it enacted these acts connected to Reconstruction, in general said, we want one place where everyone can find federal law. And they asked someone, they called them the reviser. They asked the reviser to go through and put all the federal laws that had ever been enacted into one. And the reviser, when he took the version of the law that had been enacted in 1871 and put it into the compilation, just omitted the notwithstanding clause. And we don't know why. He might have omitted it because he thought, well, the statute speaks for itself and maybe we don't need the notwithstanding clause. If that's the reason he did it, it's still consistent with the argument I'm making about the force it should have. But in any event, that's how we lost that clause. And that's why today, when anyone goes to the actual, to the statute that everyone uses in the code books, it does not have the notwithstanding clause. It just got omitted by the reviser. Who knows why? But one thing's clear. The reviser was never given the power to make substantive changes to the law.
A clerk compiling laws just deleted it. No explanation. No authorization. Gone. Let me put this together. In 1967, the Supreme Court said, Section 1983 doesn't mention defenses, so we'll use the derogation canon to keep common law immunities. But two things were wrong. Error number one, the derogation canon was never used for defenses. They applied it backwards. Error number two, Section 1983 did address defenses with the notwithstanding clause, but they were reading a corrupted version that was missing that sentence. Two errors, one toxic doctrine. And why did Congress include that notwithstanding clause in the first place? Context matters.
We have to put ourselves back in Congress's shoes in Reconstruction. The Congress of the 1870s did not trust states to enforce federal law, especially newly enacted and adopted federal amendments meant to protect especially newly emancipated black people, right? So that Congress did not trust states and localities to protect those rights. That Congress would not want state or local law to get in the way of its newly enacted federal rights. And so the notwithstanding clause is perfectly consistent with what Congress was trying to achieve. So that's piece one of the argument. Piece two of the argument is, to the extent the Supreme Court originally located the qualified immunity in state common law, this notwithstanding clause speaks pretty powerfully to an error in the court's analysis.
Congress in 1871 knew that Southern states would not enforce the constitutional rights of newly freed Black Americans. So they wrote a law that explicitly said state defenses can't block federal civil rights enforcement. That sentence got deleted just 3 years later, and 150 years of case law was built on that corrupted version. Okay, but it's been 150 years. Thousands of cases decided under qualified immunity. Isn't it too late to fix a mistake this old? Not according to judges across the country, and I mean across the spectrum. Let me give you some recent examples. March 2025, Fifth Circuit Court of Appeals Green v. Thomas. A man named Desmond Green was falsely accused of capital murder. For nearly 2 years, he sat in jail, a violent jail, based on a detective's manipulation of evidence. The detective used a drug-impaired jailhouse informant, manipulated a photo lineup, withheld exonerating evidence from the grand jury. District Court Judge Carlton Reeves, Southern District of Mississippi, denied qualified immunity. In the Fifth Circuit, Judge Don Willett is on that panel. The same Judge Willett who called Professor Reinert's research game-changing.
It's an interesting position for a judge to be in, and I have to say I sympathize with their position. And Judge Calabrese actually did a similar thing in a Second Circuit decision where he wrote the majority opinion, but also wrote a special appendix in which he didn't just address my scholarship, but other people's scholarship too. So here's the dilemma for these judges, I think, which is on one hand, maybe they think I've got it right. They at least think that it bears scrutiny and it bears examination. But they also are judges in a hierarchical system. And if they are adhering to their role within that hierarchical system, they aren't really in a position to say qualified immunity should be dead or even to operationalize their view, let's say, that qualified immunity is illegitimate. They have to wait for the Supreme Court to address the question. So I think the judges that are doing this are essentially trying to get the court's attention. And I think they've been, they're probably been successful in getting at least the attention of some of the justices. And, Justice Thomas already in 2017, well before my article came out, had expressed some concerns about qualified immunity. And in that case, he was citing to scholarship by Will Bode, who has another argument for why qualified immunity is illegitimate. So I think there's a fair amount of attention being paid to it. And I think lower court judges probably, their position has to be, I can't do away with qualified immunity, but I can call attention to the issue and hope that the court will take it up and tell us what to do about some of this research.
Second Circuit, Judge Guido Calabrese, a legendary jurist appointed by President Clinton. He stated qualified immunity, misbegotten and misguided, should go. As scholars have made more clear and more judges have come to recognize, qualified immunity cannot withstand scrutiny. He then listed judge after judge questioning the doctrine over the years. Justice Thomas, Justice Kennedy, Justice Scalia, Fifth Circuit Judge James Ho, Third Circuit Judge McKee, liberal judges, conservative judges, all saying something's wrong. These aren't activists. These are federal judges bound by precedent, crying out to the Supreme Court to fix its own mistake.
I think if they are consistent with their principles about the role of federal common law, they should. I think that would be most consistent with the principles they've espoused, that this majority has espoused in other contexts.
Here's what makes this moment different. The Supreme Court created qualified immunity. Apparently, only they can end it. But they created it based on two errors: reading the wrong version of the statute and applying the derogation canon backwards. If the current court follows its own textualist and originalist principles, the doctrine falls. The text, what Congress actually passed, overrode common law defenses. The original meaning, Reconstruction Congress protected civil rights. It wouldn't allow state law barriers. Judges know this, they're sending the signal. Now we have to wait to see if the Supreme Court listens. So let me ask the fundamental question. If we read Section 1983 correctly, with the notwithstanding clause that Congress actually wrote, should qualified immunity exist at all?
I'm willing to hear arguments. I guess maybe my interpretation of the notwithstanding clause is wrong. Maybe it doesn't mean what I think it means. But again, even if we put aside the notwithstanding clause, we've got a statute that says nothing about defenses. It's a statute that was enacted to provide a muscular federal right in a context in which Congress would never have expected it to need to specify that it didn't want some common law defense to apply. So even if my interpretation of the notwithstanding clause is wrong, still I don't think there's any justification for qualified immunity.
For over 150 years, qualified immunity has been built on two mistakes. One, a legal canon applied to defenses when it was only ever used for rights. Two, a statute missing the sentence that Congress wrote to override those defenses. 10 years ago, almost nobody was talking about qualified immunity outside of legal circles.
If you asked me 10 years ago, would we be having the discussion on a nationwide level that we are having about qualified immunity? Would people be as conscious of qualified immunity as they are today? If you asked me that question 10 years ago, I would have said, no way. It was something that scholars were interested in, and some civil rights practitioners were interested in, but it did not have the salience publicly that it has today. So I think there's a good chance it's been eroded in 10 years. I don't know if I'm confident that it's gone. And I think, but I think like any legal change, it happens incrementally, and I see signs of hope that it'll happen incrementally at the state level. I don't know. I don't know if the Supreme Court ultimately will, as I say, adhere to what I think the principles they've espoused in other contexts have been, and do away with the doctrine. But they have the power to snap their fingers, and tomorrow for it to be gone.
The sentence was missing for 150 years, but now we know it's there. Federal judges know it's there, and now you know it's there, and that changes everything. Download Professor Reinert's full article. The link is in the description. The Supreme Court just released an opinion that I think has pretty interesting implications on qualified immunity. Let's get into it. So the case actually wasn't about qualified immunity. The opinion was actually the Supreme Court refusing to expand a common law defense that judges had invented specific for military contractors. As you know, today, that same court, using the same reasoning, citing similar principles, will protect a police officer who violated your rights using a defense that judges also created or invented. I'm Brandon Grable, Texas civil rights attorney, and this is probably the most important case about qualified immunity that isn't actually about qualified immunity. That opinion had a 6-justice majority written by Clarence Thomas, and he articulated the exact reasoning that should actually collapse qualified immunity yesterday. They just applied it to contractors instead of cops. Let me show you.
The date, November 12th, 2016. Bagram Airfield, Afghanistan. A Veterans Day 5K race is minutes away from starting when Americans, both soldiers and civilian contractors, crossed paths with a suicide bomber.
Split my diaphragm in half and had a lot of shrapnel to my stomach area, which resulted in loss of my large intestines, loss of my small intestines, loss of my colon, loss of my spleen completely.
Ultimately, the blast also cost Specialist Bilyeu her leg. Major Marvin Branch almost lost something much more.
I almost lost my family.
Unfortunately, Julianne Perry was not so lucky.
I was 27 when I became a widow.
Perry's husband, John, was killed in the suicide attack. The father of 2 was one of 3 U.S. soldiers and 2 civilians murdered. A total of 16 U.S. Army soldiers were injured. Several, including those we spoke to, are based out of Fort Hood.
He was killed by a contractor who made a bomb.
The assassin was a local national, contracted by Fluor, a government contractor based in Texas. The government, in its findings, says complacency and lack of supervision by Fluor allowed for the suicide bomber to construct and employ a suicide vest inside the Bagram Airfield perimeter.
How did this guy make a bomb using your tools, your equipment, on your clock, getting paid by you.
The victims and their loved ones filed a federal lawsuit against Fluor. They have many unanswered questions.
I received a 1,000-page, heavily redacted investigation report.
It should be noted the government did not terminate its task order with Fluor, stating in this February 2018 letter, it is not currently in the government's best interest.
They're a machine that just keeps running. They don't care about who gets run over in that process.
You didn't change anything. You're just like, okay, this happened, but so what kind of thing. Let's keep going. And I don't think that's right.
In 2016, at Bagram Airfield in Afghanistan, then the largest U.S. military base in the country, a Taliban operative named Ahmed Naib walked onto the base carrying a suicide vest. He had been hired through an American military contractor called Fluor Corporation as part of a program called Afghan First, which required contractors to hire Afghan nationals to help stabilize the local economy. Army Specialist Winston Hensley, 20 years old at the time, saw Naib walking towards a Veterans Day 5K race, and he moved to confront him. Naib detonated the vest and 5 people were killed. 17 were wounded. Hensley suffered a fractured skull and brain injuries. So Hensley sued Fluor. The 4th Circuit Court of Appeals threw the case out. They said there's a doctrine called battlefield preemption, that during wartime, any tort claim against a military contractor operating under its military command is preempted. Full stop. It doesn't matter if the contractor violated its own instructions, you can't sue them because of war. Doesn't matter if the government didn't tell them to do the thing they're being sued over, the lawsuit just can't proceed. And if you're thinking, what the heck? Where did that doctrine come from? Well, good question. It didn't come from Congress and not the Constitution. Judges just made it up and they kept it up. They kept it alive. They kept expanding it. They stretched the 1988 Supreme Court case called Boyle v. United Technologies, which itself created a judge-made defense for government contractors and then expanded it into a blanket immunity for anything that happened in a war zone. On April 22nd, though, the Supreme Court said no. Justice Clarence Thomas wrote the majority opinion, and he was joined by, pay attention to this lineup because it's rare, Sotomayor, Kagan, Gorsuch, Barrett, and Jackson. That's a 6-justice coalition that cuts across every ideological line on the court, and it tells you this isn't a partisan ruling. It's a principled one. So what principle did Justice Thomas articulate? Principle 1, no preemption without text. Quote, there is no federal preemption in vacuo without a constitutional text or a federal statute to assert it. So translation, courts don't get to displace ordinary law just because they feel like there's a federal interest in the area. You need text, constitutional text or a statute. Now hold that thought. Principle 2, judge-made defenses are narrow. Boyle addresses a special circumstance in which the contractor has a defense because the government has directed a contractor to do the very thing that is the subject of the claim. Plain English, a contractor only gets this judge-made defense when the government told them to do the exact thing they're being sued over. So, for example, if the government told Fluor to build a suicide bomb, then maybe we'd be in a different position today. But if the contractor goes off script, no defense. Principle 3, Congress knows how to write immunity when it wants to. Congress knows full well how to make its intention to preclude private liability known. Translation, if Congress wanted to immunize contractors from suit, it would have said so. But guess what? It didn't. Courts shouldn't fill that gap. Does that sound familiar? Principle 4, and this is the punchline. Quote, we decline to extend Yearsley to bar allegations such as Hensley's. Essentially, that just means they decline to extend the rule from another case. So the 6 justices, including Thomas, who wrote a concurrence in a prior case in 2017, saying that qualified immunity has no basis in common law, and then was a dissent in another case in 2020, begging its colleagues to reconsider it. But now him and the majority of the court just said out loud on that page that we will not extend a judge-made defense beyond the narrow circumstance where the government actually directed the conduct. Now, let me ask you a question. Would you agree that every single principle I just told you word for word applies to qualified immunity? Yeah, let me show you. side by side. Row 1, Thomas today. No preemption without constitutional text or federal statute. Qualified immunity. As we know, there is no text. Section 1983, as passed by Congress in 1871, says that any officer who violates your constitutional rights shall be liable. They don't get to use any defense or immunity. Period. No immunity provision, no clearly established law requirement. None of it. As we know, qualified immunity was invented by the court in the 1960s and then rewritten in the 1980s. Out of thin air. They just assumed that officers should get this good faith defense. And it's only just continued to expand and worsen for Americans since then. Row 2, Thomas today. A contractor only gets a defense when the government directed the very thing at issue. Qualified immunity protects officers for conduct no one directed. So even conduct that violates their own department's written policy, even conduct where the department ends up firing the officers for, the officer still gets qualified immunity. Row 3, Thomas today. Congress knows how to create immunity when it wants. Qualified immunity, Congress wrote Section 1983 not allowing for immunity, but the court added it anyway. Row 4, Thomas today about U.S.C. The defense applies only when the contractor is being sued precisely for accomplishing what the federal government requested. Qualified immunity protects officers for constitutional violations they were never authorized to commit. Row 5, Thomas today, we decline to extend. Qualified immunity, the court just keeps extending it. Pearson v. Callahan made it easier to grant without even reaching the constitutional question. The courts just ask now, was it clearly established? Decision after decision, judge-made defense grows. This is the double standard. When it's a contractor who may be negligent, let a bomber onto a U.S. base, the court says, no judge-made immunity. Let that tort case proceed. But when it's a cop who tased a kid, shot someone in the back, or beat a handcuffed man 133 times, the court says, here's a judge-made immunity. We invented it. Case dismissed. Same court, same term, different result. Professor Alex Reinert, he proved that the version of Section 1983 the Supreme Court has been interpreting is literally missing a sentence that Congress actually wrote. And I asked him about Hensley during that interview about this specific case before it was decided.
Interestingly, this term, there's going to be a case, Hensley versus Fluor Corporation, which poses the question of whether or not to expand the Boyle federal common law defense to a different context. And I'm really interested in what the court does there, because again, if the court is being true to its hostility to federal common law, it should run maybe against common law defenses even more than it might run against federal common law claims.
He called it months ago. He said if the court is honest about what it claims to believe, if it is really hostile to judge-made law, it should run away from judge-made defenses, not just judge-made rights. And in that Hensley opinion, that is exactly what 6 justices did.
If the court was adhering to its principles consistently, qualified immunity would be more tenuous. It wouldn't survive scrutiny. Because if the court is consistent, truly consistent with the reasoning it put on the page in the Hensley case, then qualified immunity collapses. Judge made? Check. No statutory text? Check. Not in the Constitution? Check. Protects conduct the government never authorized? Check. Congress knows how to write immunity and chose not to? Check. So everything Thomas just said about Boyle and U.S.C. in this Hensley case applies with greater force to qualified immunity, because qualified immunity isn't limited to people acting within their authority. It's broader. It's worse. So why is qualified immunity still here? Well, 2 reasons. First, stare decisis. The court hides behind its own past decisions. They've ruled on qualified immunity so many times that overturning it now feels like institutionally destabilizing, even when the reasoning is indefensible. Second, nobody wants to be the court that tells every police officer in America that they could be personally sued. But here's why that case matters today. The intellectual foundation is crumbling in real time. Thomas has already said in print that qualified immunity has no historical basis. Today, he wrote a majority opinion refusing to extend a parallel doctrine using reasoning that would destroy qualified immunity. Gorsuch and Barrett joined him. Sotomayor, Kagan, and Jackson joined him. 6 judges on the record saying that judge-made defenses don't extend past the narrow circumstance where the government directed the conduct. That's not nothing. That's the scaffolding for the case to end qualified immunity. Somebody just has to bring it. So here's a question I want to leave you with if it hasn't clicked yet.
If a military contractor loses his judge-made defense because he acted outside of his authority, why does a police officer keep his or hers? The court just answered that question for contractors. It needs to answer it for cops. If you think a doctrine invented by judges with no basis in the Constitution or statute that protects conduct the government never authorized shouldn't be the law, well, share this video. If you're a lawyer with a qualified immunity case on appeal right now, you need to read Hensley now. The language is there. Use it.